When Congress passed the first patent law in 1790, it guaranteed in law the exclusive rights of patent owners to their inventions. When those rights were infringed, patent owners sought redress in the federal courts. In modern times, patent enforcement has become a long and very expensive process. Parties will often try to settle disputes over patent rights out of court or through a licensing agreement. Patent litigation serves a vital function in society by settling the validity and disputed ownership of patent rights so these can be commercialized into new products, services, and medical treatments. Who is responsible for enforcing patent rights? The USPTO is responsible only for examining and issuing patents, not enforcement. It is up to the owner of the patent, called the patentee, to enforce it against infringers by filing a civil case in federal court for patent infringement. The patentee has the statutory right to exclude others from making, using, selling, or importing the patented invention throughout the U.S. Patentee Robert Kearns, who was granted a patent on intermittent windshield wipers in 1967, exercised his statutory right when he filed patent infringement lawsuits against Ford Motor Company and Chrysler Corporation in the 1990s. Eventually, his lawsuits were a success. It is important to note that patent rights only exclude others from using the patentee's invention. The Patent Act does not grant the patent owner the right to practice the invention covered by the patent. What is patent infringement? Infringement is a strict liability violation. You do not need to know that you are infringing a patent or that a patent even exists to be liable for patent infringement. If someone makes, uses, offers for sale, sells, or imports what is covered by a claim of a valid patent, that person is an infringer. Neither lack of knowledge of the patent nor lack of intent to infringe it is a valid defense to patent infringement. To decide whether someone is infringing your patent, the elements of each claim of the patent must be compared with the elements of the potential infringer's device or process. If the elements of a patent claim match the elements of the device or process, an infringement has occurred. Even if elements of a claim do not literally match the infringing device, they may be infringed under the doctrine of equivalence. This doctrine prevents someone from copying the essence of an invention and making insignificant modifications to avoid infringement. If the accused device or process performs substantially the same function in substantially the same way and yields substantially the same result, infringement exists so long as any differences between the claim elements and the accused device are not substantial. What should you do if you believe your patent is being infringed? The first step is to hire a patent trial lawyer. The lawyer will evaluate the patent and the accused device or process to provide a legal opinion about whether or not an infringement exists. If an infringement is found, the patentee must decide how to proceed. Here are 4 options for pursuing a patent infringement claim. 1. Demand that the alleged infringer stop infringing and pay damages for past infringement. 2. Offer the alleged infringer a license to practice your invention for money, called a royalty. 3. Ignore the infringement or postpone any action for a time. 4. File a patent infringement lawsuit in federal court against the alleged infringer. The decision of how to proceed depends on the patentee's objectives and a clear understanding of the risks and rewards of each potential course of action. What is the best option for pursuing a patent infringement claim? Litigation or licensing? Litigation. If your goal is to stop a competitor from offering a competing product that infringes your patent, you have to file a lawsuit and pursue it to completion. Litigation can easily cost from $1 million to over $10 million, depending upon the complexity of the case and the intensity of the defense. If you cannot afford litigation, there are contingency fee lawyers who may be willing to take your case in return for a share of any damages collected from the infringer. These contingency fees are typically between 30% and 40%. There are also a wide variety of litigation finance firms that may be willing to fund your litigation in return for shares of any damage award or settlement payment received. Licensing. If your goal is to obtain a royalty for the use of your invention, you may be able to negotiate a license agreement without the need for litigation. Often, lawsuits can be settled via a license agreement short of trial. About 95% of patent lawsuits settle before trial, with many defendants taking a license for which they pay a royalty. Even small entities and individuals can successfully license a patent without filing a lawsuit if they have a good patent and a reasonable licensing plan. Most prospective licensees know that lawsuits are very expensive and would prefer to settle a dispute with a license rather than fight a lawsuit. The key to defending and enforcing your patent rights is to have a plan and implement it diligently with good counsel supporting the effort.